Hi, welcome to the second episode on our series on tenancy laws. Are there any specific laws for non-resident Indians and especially NRI landlords to get their properties vacated? That's the first question which is going to be addressed. Secondly, now if there are separate states in the country, are there specific state laws which deal with the landlord issues? Now coming to the first point. NRI landlord specific laws. The only state which provides for this provision is Punjab. Earlier, the act, which is now repealed but is still applicable for any tenancies which were carried before 1995, is the East Punjab Rent Restriction Act. The Section 13B was very specific, was a specific provision for non-resident Indian, which has been taken over in the Punjab Rent Act, which also covers eviction for NRI landlords. Now, the Punjab Rent Act also has a special provision for widows. Now, for people who do not come under the NRI category, can claim, and if it's a widow, she can claim eviction of a property under the Section 24 of the Punjab Rent Act. Now comes Mumbai, Maharashtra, Gujarat. Earlier, Bombay, the only act applying to Bombay and Gujarat was the Bombay Rent, Hotel and Lodging Act of 1947. The Section 13 was categoric about eviction of tenants on basis of personal necessities, subletting of properties, non-payment of rent. Now, Bombay has a separate act, which is the Maharashtra Rent Control Act. So, entire Maharashtra is covered under the act. And for Gujarat, we have the Model Tenancy Act of 2021. Now, what has become specific under these acts is that the rent agreement has to be in writing. There is no way. Earlier we were going on assumptions that he's considered as a tenant because the rent has been deposited in the accounts and he can be assumed to be the tenant. There were rent receipts being issued. Today these acts are extremely and exceptionally categoric about the rent agreement being present. Now comes Kerala, which is the Kerala Building Lease and Rent Control Act of 1965. Section 11 of Kerala Rent Act again provides for eviction of tenants, again for non-payment of rent, subletting of property, and a person requiring it for personal need. But again, the requirement is your rent agreement in place. Now, similarly, the Delhi Rent Control Act also provides for provisions again for widows, for a person who's a landlord, and has a requirement for personal necessity. Now the question is, what do you mean by personal necessity? How do you show that you have a personal need? So any person, let's say, is living abroad, wants to, even if he doesn't want to permanently come and set abode here, but requires the property whenever he comes back to India for his family, or he doesn't want to spend on hotels, that's a ground for personal necessity. Similarly, for commercial shops, if India does not bar a non-resident Indian from setting up a business or using his commercial property for his personal need. So he can use a property, which is a shop or anything, for setting up his own business. So these are things which get covered on the grounds for personal necessity. Now, these acts that I'm talking about talk about the properties mostly covered in the urban areas. Now, Punjab is very specific. I am not talking here about houses which are in the villages. For that we cannot go under the Rent Act. Punjab is very clear on that. It is only for urban properties. Similarly, for most of the properties, when people hear, I'm a landlord, he's a tenant, we want them vacated, this law is going to, no, the rent law does not apply to agricultural lands. It does not. For the person who is sitting in possession of your agricultural land, and even if he's a tenant, he cannot be evicted under these rent acts. These rent acts that I'm talking about are for buildings, are for shops, are for houses, are for a building which is constructed in an urban area. It could be an industrial shed or whatsoever. But when you're talking about agricultural land which have been given to tenants for years, there are different acts again which are going to be applying to you. Those come under the revenue section and not under this. Now, even of course there are, so you might, the question now comes is that, do we have to go to another court to do this? What are the laws? Now, this is again very circumstantial, again depending on the documents that have been drawn between the landlord and the tenant. If there is an agreement between the landlord and a tenant, we go to a separate court. If no agreement, it is just on the oral agreement, or just an understanding that land was given to somebody who refuses to vacate, it's a separate court we go to. But then if, let's say, there is a person who's been sitting on your land for years, even if it was a mutual understanding, but his name is appearing on the documents in possession, then we have to find a different route to do that. I'm hoping that this video has made some sense or has given you some kind of an input in case somebody is a landlord and is looking for answers and what law is going to apply to them. In case of any questions, you can contact us, and I'm sure you're going to like the video. Thank you for watching.